Good afternoon, everyone. Good morning, everyone, depending where you are. By way of introduction, my name is Ahmad Saleh. I am partner and head of patents and designs, R&D and innovation at Altam and Company law firm. To start with, first of all, I would like to welcome you all to this webinar and thank you for your valuable time in joining us in this interesting webinar we are holding with respect to intellectual property protection in China. I'm delighted also to be joined by my colleague Zodi Wang, who is a Chinese qualified trademark and patent attorney, and she's part of our Altam and Company family. So the webinar will be structured in the following manner. I will introduce for a couple of minutes our firm and why we are holding this IP seminar in relation to China, highlighting the importance of IP protection in China. I will then leave it to my colleague Zodi to go through the IP protection regime in China in terms of IP registration and enforcement. And we'll have a 10 to 15 minutes questions and answers session at the end to answer your queries. So to start with, I would like to quickly present our firm, Altam and Company, as perhaps many of you already know, is the largest law firm in the Middle East. We have presence in 9 countries in the region, in all the GCC countries, in addition to Jordan, Iraq, and Egypt. And we have expansion plans in North Africa, where we'll be opening some new offices in the upcoming period. So we have in total of 17 offices for now. We are 73 partners in the firm, over 350 lawyers, 150 legal professionals, 850 employees, and we have more than 50 nationalities working under one roof throughout the firm, which we are very proud of. We are in the overall one fully integrated law firm working all together as one family for the ultimate benefit of our clients. As I mentioned, we have presence in all the GCC countries, which are UAE, Saudi Arabia, Bahrain, Qatar, Oman, Kuwait, as well as in Iraq, Jordan, and Egypt. In the UAE, we have multiple offices in Dubai, Abu Dhabi, and other Northern Emirates. In Saudi Arabia, we have 3 offices in Al Khabar, Jeddah, and Riyadh. As I mentioned, we have also plans of expansion throughout the region. Our services expand to a large spectrum of services, all of what you can think about in terms of legal services, from intellectual property to corporate structuring, to competition, to commercial, to financial crimes, to regulatory, and so on. In terms of sectors, we're also proud to be structured both in terms of legal practices and in terms of specialties, in terms of business sectors as well. So we have cross-functional teams coming with different legal backgrounds, all specialized in certain sectors, for example, defense and security, education, energy, financial services, healthcare, and so on. And we do also have country groups such as China, India, Korea, Russia, and Turkey help desks to help our clients bridge the cultural, legal gaps and complexities between the Middle East and between these countries, representing clients from both sides, from the Middle Eastern companies and helping them to transition or to bridge the gaps with the foreign countries, all in working with our foreign associates in these countries. And we do also represent foreign clients coming from these countries into bridging the gaps, of course, with the Middle East. So the importance of this seminar today is, first of all, it's if I ask the question, no one today doubt that China is, if not already, one of the superpowers in terms of economy in the world, and the Chinese market is not something which can be ignored for most companies doing business and trade on the international arena. So without any doubt that China is one of the largest economies in the world today. And when we speak about the largest economies in the world, for sure, we immediately highlight the importance of the protection of the companies doing business in China in terms of trade and intellectual property assets. So for any company connected to the Chinese market, having plans to expand to the Chinese market or already doing business in the Chinese market, it's highly important and recommended for these companies to have IP strategy as part of the business plans in China. Now, about asking about the IP regime in China, I'll perhaps highlight some quick history with respect to the advancement of the IP regime in China. So since the late 70s, beginning 80s, and the reform in China, China has taken very serious steps into adopting IP protection and enforcement laws in China. So in the 90s, we've seen the adoption of many IP laws in China, from patents to copyright to trademark laws. And in 2001, after the accession of China to the World Trade Organization, WTO, we've seen many improvements and advancements of the Chinese IP system and regime, both on the protection and on the enforcement side of things. So we've seen even specialized IP tribunals taking place in China, and we've seen very effective, actually, enforcement regimes, which my colleague will speak about, which include administrative kind of procedures for the enforcement of IP in China. And we've seen also many, and what helped actually the advancement of this are many negotiations and discussions between China and other countries in terms of the strengthening of IP regime in China. And China recognizes that strengthening its IP regime, it's part of improving, strengthening the economic and political ties with other countries and strengthening its local innovation and commercial and trade systems as well. We do understand that there are still some concerns by some companies in terms of the counterfeiting activities in China and other issues. And this is where the importance of adopting a very effective IP strategy for companies doing business in China. Just to highlight quickly how China has advanced on the IP side, we are going to present two slides of statistics just to show the number of IP rights which have been registered in China since the 80s. As you can see in this slide, between the 1980 and today, so between the reform and today, you can see that the number of IP registrations has increased exponentially. And today we can say that the number of IP registrations in China hit almost more than 5 million registrations. And this is maybe around half of the global IP registrations are taking place in China. If we go a little bit further, perhaps we will notice that a big portion of these registrations taking place in China are also filed by Chinese companies. So so this is foreign companies filing for IP registrations in China, plus local companies filing for IP registrations in China. Maybe the big chunk of these are Chinese companies filing for IP registrations in China. We're going to present another statistic. This is with respect to the Chinese companies filing for international patent applications. So this highlights as well how the Chinese local companies are getting involved more and more in expanding their presence to the global market and filing their patent applications through the World Intellectual Property Organization with the intention of course, registering their rights in foreign countries. And here we can see how how China has quickly advanced through the ranks to become #1 in terms of patent filings in the World IP organization with respect to PCT applications. So this is a little bit of a glance on the importance of IP protection in China, and I'm going to leave it now to my colleague Zodi to take it forward with respect to discussing more in detail the IP regime in China.
Thank you, Ahmed, for the introduction, and thank you all for joining this webinar. So in the following, I will discuss the Chinese patent and trademark protection, as well as the patent enforcement in China. So the Patent Office in China is the China National Intellectual Property Administration, short for CNIPA. So in China, we have 3 types of patent: invention patent, utility model patent, and design patent. The highlight and the differences of the 3 types of patent are listed in this table. A Chinese invention patent protects new technical solution relating to product, a process, or an improvement thereof. A Chinese invention patent undergoes a substantive examination in which novelty and inventive steps are examined by the Chinese Patent Office. The protection term for invention patent is 20 years. A Chinese utility model, on the other hand, covers a new technical solution relating to the product shape, structure, and a combination thereof. The protection term for utility model is 10 years. Design patent protect shapes, patent, and the combination of colors, shapes, and patent which have aesthetic appeal. the protection of design patents is newly amended to extend to 15 years. Since there is no substantive examination of utility model and design patent, the registration of these two types of patents is very, very fast. And invention patents and utility model application can be filed directly by the Chinese Patent Office, claiming priority over first foreign filing or via PCT route. So the time limit for national phase entry in China is 30 months, counted from the international filing date or the earliest priority date. The time limits can also be extended to 32 months upon payment of a corresponding official fee. Please note that for filing applications in China, all the filing documents need to be translated in Chinese. It is also worth mentioning that the protection of Chinese patents can only cover the mainland of China. If you want your invention patent to be protected in Hong Kong or in Macau, you have to file a formal request to extend the patent to Hong Kong and Macau after grant of the patent. For obtaining patent protection in Taiwan, a separate patent application should be filed with Taiwan Intellectual Property Office. According to the statistics, foreign companies file many invention patents in China. Utility models are used extensively by Chinese applicants, but foreign companies have filed only a small number of utility models and designs. As shown in the diagram on the upper right corner of this slide, in the year of 2020, 99.5% of utility model applications were filed by Chinese applicants. Foreign applicants filed only 0.5%. So a possible explanation is that foreign applicants, particularly those from countries where no similar system exists, are simply unfamiliar with Chinese utility model and designs. However, the Chinese utility model system can be used to strategically to enhance the scope of patent protection in China. Utility model patents are registered after a formal examination, which generally takes about 8 to 12 months. In contrast, invention patents are substantively examined, so that the examination can take 3 years to grant. Besides, the cost of utility model registration is much lower than invention patent. It should also be noted that method, processes, and chemical compound cannot be protected by utility models. It is in China a very common practice that an applicant can apply for both invention and utility model patent on the same invention at the same time. When the invention patent is granted and have the same protection scope as the utility model, the applicant must abandon the utility model patent. Such a strategy has advantages because the relative short period of time from filing to registration of a utility model can be combined with the longer term of our invention patent to yield an extended period of time during which an enforceable right is available. Moreover, objections on inventive grounds during prosecution of the invention patent may not necessarily affect the enforceability of the utility model because the standard for evaluating the inventiveness in utility model invalidation proceeding is different from the standard for invention patent. In other words, the requirement on the inventive step of utility model is lower than that of invention patent. As shown in the diagram on the right, according to the statistic, only 34% of utility model can be completely invalidated during the invalidation procedure, compared to the percentage on invention patent is nearly 46%. Also, if the utility model patent and the invention patent have different scope of protection, there will be no double patenting issues in China. The applicant can therefore take the strategy even further by initially filing broader claims in the utility model application while pursuing narrower claims in the invention application. Therefore, the utility model is a quick and cost-efficient way to protect the product with a short life cycle. Invention patents may not be desirable for products with short life cycles because the prosecution can take several years and can be very costly to maintain. The aforementioned strategy of filing both invention patent and utility model patent at the same time applies for direct national filings. If the Chinese application is filed via PCT route, upon entry into national phase in China, foreign applicant must choose to either to enter either as an invention patent or a utility model application, but not both. However, a sophisticated applicant may also want to consider filing utility models in China for patentability reasons. As discussed before, utility models are not substantively exempt, and the invalidation based on lack of inventiveness is difficult. So for those applications that may have difficulty in terms of inventive steps, applicants can strategically choose to enter China as utility model applications. This strategy can quickly obtain an enforceable utility model patent application. Further, the utility model can also be used in case where urgent protection is needed. For example, if a product launch in China is rapidly approaching, a utility model application can be filed quickly without time required to draft the application in detail. In very extreme cases, the utility model application can be filed with narrow claims that may only cover the actual product. So the foreign companies should also consider the design patents in China. The design patent protection in China plays a significant role in protecting innovative industry designs, and it can be used as a cost-effective tool for stopping the flow of infringing designs onto the global market. The application process for design is relatively fast and cost-effective. Together with the application, the applicant must submit drawings or pictures and a brief description of the design, setting out the essential features of the design. And the design patents in China are not subject to any substantive examination. The Chinese office will only check whether the design is protectable, whether the formalities have been compliant, and that the application fees has been paid. So the registration of a design will take about 8 to 12 months. In China, it is also possible to file graphic user interface design as well as partial design application. As mentioned by Ahmed before, the patent law of China was originally established in the year of 1985, and it was amended for 4 times. The fourth amendment of the Chinese patent law just entered into the force as on the 1st of June this year. Below diagram shows the major changes in the new patent law. I will discuss some important changes which might be interesting for you. The protection term of the design is extended to 15 years. Also, partial design, which means a design of a part of a concrete product, but not of the entire product, becomes patentable. In the previous Chinese patent law, a design application must be for the entire product. This change makes the law more friendly to designers who intend to have the design protection on their designs. Another very important change is for the infringement litigation. The upper limit of the statutory damages, which means the damages avoided by the handling court's discretion, is lifted to amounting 5 million RMB, which is about 715,000. This is obviously an application of the idea of stressing the patent protection. Moreover, the acts of willful, serious infringement of patent right are subject to punitive damages of up to 5 times of regular damages. Without question, this amendment makes it possible for patentees to collect relative high damages when they face willful and severe infringement. Another very important change is the open license. In the new amendment, an open license mechanism is introduced. The patentee may declare to the Chinese Patent Office that his patent is licensed to any entities at indicated royalties. So any parties who are interested in license may obtain it simply by notifying the patentee and paying the required royalties without any further negotiations with the patentee. So all the information can be checked in the Chinese online patent register. Under this website, patent information, including examination process, possible invalidation process, and assignments can be searched. So in this section, I would like to discuss the trademark protection in China. If you look at the diagram on the right, you will see how fast the binding numbers of Chinese trademarks increases since 2010. In the year of 2019, nearly 8 million trademarks were filed in China. And there are some general information of trademark filings and registrations. A Chinese trademark can be registered directly at the Chinese Trademark Office, and the applicant may also claim priority of a previous first application. The Chinese trademark can also be obtained by designating China under the Madrid Protocol application, which is the international trademark application. And similar as the other countries, in China, trademarks are protected for a period of 10 years from registration and may be renewed as often as designed for additional 10 years period. In China, there is a use requirement for trademark. To remain valid, a trademark must be used in commerce at least once every 3 years. In other words, if a registered trademark has not been used for an uninterrupted period of 3 years without proper reasons, it can be cancelled. There are also 2 very important points worth mentioning: the multi-class applications and subclasses. In many countries, it is possible to file single application covering multi-classes, so-called multi-class applications, in order to save cost. The multi-class applications are available in China. However, there are certain limitations and disadvantages. First, the official fee for filing multiple single class applications and that of a multi-class application are the same. There is no difference in the official fees. Second, under current practice, a trademark owner cannot divide a multi-class application voluntarily. If one of the classes faces opposition, the whole trademark application cannot proceed to registration until the opposition is overcome. Also, the trademark owner cannot renew only one class in a multi-class registration. And the trademark owner can also not assign one of the classes to other parties. Instead, the complete registration must be assigned and renewed together. Therefore, filing single class applications separately provides the owner more flexibility. It is also, China also uses the niche classification. However, China divides each niche classes into subclasses. This is very unique in China. The goods and services are grouped in both niche class and the underlying subclass. It is very important when registering a trademark that the registration covers product and services in each of the subclasses containing product and services that may be relevant to your business. Please also note that trademark registered in mainland China does not provide protection in Hong Kong, Macau, or Taiwan. If you want protection in these territories, you will need to register your trademarks separately and directly in these territories. And the process of the Chinese trademark registration can be summarized in the flowchart below. After filing the trademark application, the application undergoes a formal examination and a substantive examination. If all the requirements are met, the Chinese Patent Office will arrange publication of the trademark application in 1 or 2 months. Opposition can be filed within 3 months after publication. The registration certificate will be issued within 1 month after the opposition period. Another very important thing is about the registration of marks in Chinese language. Since the registration of a trademark in foreign language characters does not automatically protect the trademark against the use of registration of the same or similar trademark written in Chinese, it is highly advisable to register a Chinese version of the foreign trademark. The brand name is a very important purchase criterion, and one good name often says more than 1,000 words to the customer. Therefore, Chinese characters should be found for the foreign brand name, which have the most positive and appropriate meaning for the brand, and in the best case, also sounds similar. A successful Chinese brand name should be memorable, easy to pronounce, and emotionally appealing, and also have a similar pronunciation and meaning to the Western brand name. To achieve this goal, 4 methods can be used to translate the brand name into Chinese. The first method is called the new creation. In this method, completely new names are sought that have no similarity in sound or content to the original. In order to create a new brand name, it is very important to adapt it to the Chinese culture and consider the characteristic of the product. This method is useful especially for the brands which are not yet known in China. So on this slide, there are several examples. For example, the Chinese name of Pizza Hut is 必胜客 in Chinese, which sounds very different to the original mark. The meaning of the Chinese name is customers must be victorious. The phonetic translation is the most commonly used method for translating the brand name into Chinese. There, the foreign names is adapted as correctly as possible to the Chinese syllables structure without paying attention to the meaning. The brand is then standardized worldwide with the same pronunciation. Here, syllables with the same pronunciation must be selected in order to combine matching Chinese characters. In phonetic translation, it is especially important to avoid Chinese characters with negative meanings and unattractive sounds. One problem with this method is that the resulting names often become very long. The problem is often solved by using only the first 2 or 3 syllables. A good example is the German automobile manufacturer Audi. The pronunciation of its Chinese name is Audi, which is the same as the original, but the Chinese name does not have any meaning. The next method is the semantic translation. With this method, the brand name are translated in terms of meaning. The original sound no longer plays a role. The method is therefore recommended for brand names where the meaning component is already very strong in the original. Sometimes the original meanings can be adapted if they do not evoke the same positive associations in China as in the foreign countries. There are also some nice examples. The Chinese name of Microsoft is Weiran, which has the meaning of small and soft. Particularly successful translations combine all the methods. The combined translation sounds both similar to the original and has a suitable meaning. When translating, you must first choose the appropriate syllable, then select the corresponding Chinese character with positive meaning. When choosing characters, it is not recommended to use the most frequently or very rarely used characters. This method requires high detailed knowledge about the Chinese market, Chinese language, and brand values. For example, the Chinese translation of the mark Coca-Cola is very successful. The Chinese name is 可口可乐, which sounds similar to Coca-Cola. It also has a very good meaning, tastes good, and makes you happy. There are also some strategies for the trademark registration in China. First one is the early registration. It is highly recommended to apply for the respective trademark in China as soon as possible. And when registering a trademark, it is important that the registration covers the products and services in all the subclasses and subsections which contain relevant products and services for the applicant. This may prevent imitators from registering an identical or similar mark in such subclass, thereby weakening the mark. So make sure to register your trademark for the correct class and the subclasses. It is also advisable to register not only your trademark in your home language, but also the counterpart in Chinese characters. If the trademark producers protect their trademark exclusively in their home language, trademark pirates may succeed in obtaining the Chinese language trademarks used by these companies in bad faith. And when choosing a Chinese name, it is essential to consult a Chinese native speaker to give the brand the right image in China and to avoid costly mistakes from the beginning. The defensive trademark registration should also be considered as a protection against the trademark piracy. This means, for example, filing variations of marks actually used. It is also conceivable to file applications in neighborhood classes of goods and services. So the last section is about IP enforcement in China. To protect the IP of your product, it is very important for you as right holders to actively enforce your IP right for brand reputation and social responsibility. How to strike IP infringement quickly and effectively has become one of the most concerning issues for many foreign companies in China. I would like to provide a brief introduction to the unique system of IP protection in China, in which IP enforcement can be carried out through local administrative protection, court litigation, or both, as well as some other enforcement methods. The administrative enforcement is a unique and important way of enforcing IP in China. IP right holders can stop infringement quickly by filing a petition with local administrative authorities with materials showing their legal right and preliminary infringement evidence. The administrative authorities should investigate the alleged infringement and also have the legal power to stop infringement, issuing fines, on-site inspection, as well as seizing infringing products. As a practical matter, compared with civil litigation, administrative protection can be achieved by providing just the preliminary evidence of suspected infringement and with a lower cost and shorter case cycle. That is why it is an enforcement measure widely adopted by right holders in China, especially for trademarks. This procedure is also important because since court discovery is not available in China, administrative enforcement can provide official records and other evidence acceptable to the court. So it is therefore a very powerful aid to IP infringement in litigation intended to be filed later. It is also worth noting that when the administrative authorities confirm the infringement, they have the right to impose a certain amount of administrative fine on the infringer for disturbing social order with an illegal act. This kind of administrative penalty, however, is different from court compensation for infringement in civil litigation and will be turned over to the state's treasury, not to the right holder. So if the right holder need to claim compensation for infringement from the infringer, it is necessary to file a civil litigation. Overall, the administrative enforcement procedure is very cheap and effective at removing infringing product if you are not concerned about seeking damages, and it is particularly effective at enforcing your trademark right. And as discussed on the last slide, the administrative enforcement is particularly effective at enforcing trademark right. The administrative protection of patent right may not be as quick as strong as trademark right due to technical difficulties. Generally speaking, patent right holders prefer to choose civil litigation to enforce their patent right instead, and optionally using administrative enforcement for evidence collection. If the enforcements turned out to be large scale and cause great damages to the IP holders, it is common for foreign companies to initiate civil litigation to claim compensation. The infringement litigation is handled by IP tribunals and IP court in China. Until now, there are 3 specialized IP courts in Beijing, Shanghai, and Guangzhou, and 22 specialized IP tribunals in other cities. And recently, the Chinese trademark law and patent law were amended to raise the limit of statutory compensation to 5 million yuan, and the limit of punitive damages from 3 to 5 times of the losers or infringers' profit, thus making it more appealing than ever to now go after infringers in China. Therefore, it is more favorable for foreign companies to use litigation as a weapon to recover illegal riches taken by infringers. This will also act as a deterrent to other copycats in the market. So litigation has its advantages and disadvantages. It is very effective in issuing compensation and providing a deterrent for future infringers. However, it comes at much higher prices and typically takes much longer than administrative enforcement. There are also some other enforcement actions like customer IP protection. So customs IP protection is another effective route to protect your IP. Custom authorities can prevent the infringing product from being exported or imported. The IP right holders are permitted to record their rights in the customer record system. When IP rights are recorded, the custom authorities should actively make routine inspection on goods to check infringement and inform the IP right holder. Criminal litigation can also be sought under the situation where the counterfeiting is very serious and the threshold for the crime is reached, but the criminal litigation is rarely used in China. It is also very important to know that in China, dispute resolution system, mediation may be involved during the life cycle of a civil litigation case. The parties may reach a settlement at any stage from the written hearing or court trial to the enforcement stage of a civil judgment. Therefore, there is a tip for foreign companies. Filing a civil litigation case does not prevent you from reaching a private settlement with the infringer outside court or through court mediation. Litigation and mediation can be parallel proceedings. An agreement on infringement compensation can reduce cost and risk associated with litigation, including time and money. So in the last, there are some takeaway messages for you. As discussed before, for foreign companies, the values of Chinese utility models and design patents are often underestimated. These 2 types of patents in China have many advantages. By devising your patent filing strategies in China, please consider these 2 very important and useful patent types. The second, as you all know, IP is a very valuable asset that can support your business expansion abroad. If you wish to enter the Chinese market or are already doing business in China, it is recommended that you apply to protect your IP right as soon as possible. The third important thing is filing trademark in the Chinese language because registration in foreign language characters does not automatically protect the trademark against the use or registration of the same or similar trademark written in Chinese. Last one, when you identify infringement, please enforce your right. If you build a reputation for being litigious, others will be less likely to infringe your right in the future. China is a huge market that is offering opportunities for all the companies worldwide. China's IP protection system is getting more mature, fair, efficient, and powerful than ever before. It is advisable that you, as IP owners, strategically plan your IP protection in China and take advantage of the various ways of IP enforcement, especially administrative enforcement and mediation, in addition to litigation enforcement. Thank you very much.
Thank you very much, Zodi, for the comprehensive explanations and details about the IP protection regime and enforcement regime in China. It's good that we still have 10 minutes for questions and answers. So please feel free to post your questions. We will be responding to these. Until we receive questions from the audience. So it's important to mention that IP protection, IP registration is, of course, one of the different components of an effective IP strategy in China, and is not the only one. So an effective IP strategy in China takes into consideration the IP registration, of course, and enforcement of your rights in China. And it's important to well assess your assets, your IP portfolio, and to decide which assets are to be protected in China and through which vehicles. Is it utility design or is patents? For trademarks, of course, if you're doing business in China or have your products distributed in the Chinese market, it's very important to protect your brands in China. Manufacturing your products in China also dictates you having an effective IP strategy there, which may involve, of course, IP registration and other effective strategies for also preserving or taking preventive measures of preserving your IP right there. Some of them may involve, for example, an effective strategy of dealing with local manufacturing companies or managing your manufacturing process effectively in such a way that to minimize disclosure to one single entity, for example, or to disclose this process. So an effective IP strategy takes into considerations multiple aspects. Other aspect, if you're doing business with entity there and you're concluding agreements with these entities, which involves, for example, the transfer of know-how or licensing, it's also important to well manage what kind of information is being released, what kind of know-how is being transferred, what to keep, what to transfer, what to license. And so all of this needs to be balanced appropriately. So, always keep in mind that a good IP strategy is an IP strategy that takes into consideration the law, not only, but also the business parameters and the business reality of things, and from the practical perspective, and take into consideration other cultural aspects as well. Of course, Zodi and I will be happy to support you all with any specific queries in relation to IP in strategies and protections in China. I'm not sure if our question and answer section is working appropriately. Okay. So I have a question here for Zodi. Zodi, in terms of enforcement of trademarks right in front of the administrative authorities, how much normally time it takes for one to submit a complaint to the administrative authority in China, and until they get a decision to seize the counterfeit goods and to stop. And is it a similar process to the one in the UAE, in a way where administrative authorities, they conduct their investigation and they go and they raid and they see the product, they destruct it, or is it different?
It's similar to the UAE administrative enforcement method, but in China, the time frame depends on the different cities. Some authorities in some very small cities, they don't have a lot of IP knowledge, so they will handle the case slowly. But for some other cities like Shanghai and Beijing, if you file a petition by at the administrative authority, they will take action very quickly. Maybe within 2 or 3 months, they will find the infringement and make the decision.
Okay, very good. And is it similar in the patents case and industrial designs case? Because we know that in the UAE, from the administrative perspective, it is not possible to administratively enforce patent rights, for example, practically speaking, though it's provided under the law. So how is the situation in China, and how effective are the administrative procedures for that?
Yeah, in China, it is also possible to enforce your patent right via the administrative enforcement. However, it's not very recommended because a lot of people, they don't know patents, they don't know the technologies. So you need a lawyer who can explain the technologies very, very clear to the people who are handling the case. It's not very recommended, but it's possible in China, especially for utility models and designs. If the protected subject matter is a product, have the structure features, it can be better enforced via the administrative action than the invention patent.
Okay, okay. Some queries in relation to concerns with respect to the effective enforcement of rights by the tribunals, so in China. So how are the Chinese tribunals and courts are treating foreign companies trying to enforce their rights in China? Are they receiving the same kind of treatment as local companies trying to enforce their rights in China? This has been, always the elephant inside the room no one wants to talk about, but, all the companies have their concerns in this respect.
Yeah.
Can you give us some clarity in this respect?
Yeah, yes, previously China has such kind of local protectionisms. The local companies were protected by the government. But recently, since the 5 years, the foreign companies as patenting in China are more protected. There is no difference, I would like to say. Yeah, the Chinese judges and the lawyers, all they are very professional. They have more and more experience, and China becomes international. So a lot of foreign companies are doing business there. So I would like to say there will be almost no difference between the Chinese and the foreign companies who are protecting or defending their IP in China.
Okay, thank you very much, Zodi, for this. I think this brings brings end to the webinar. It's 1 o'clock Dubai time. We hope that you found this webinar useful. And thank you again for your attendance. If you have any specific queries or questions, please don't hesitate to reach out to us, and we wish you a very wonderful day. Thank you.
Thank you.